and today's our Tuesday 3 p.m. real estate investing zoom.com call. We get together with wholesalers, real estate agents, investors, brand new wannabe investors, experienced investors, and some vendors, and talk about the real estate market, how to buy property, make money at it, increasing our income and increasing our wealth. And so we have a variety of different topics that we talk about, and we have different guests that come on from time to time and try to help us become more successful in our endeavor. So if you're watching this on the live stream, either on YouTube or Facebook or LinkedIn, put your comments in there as well, and we will respond to them. If you're watching it on the Zoom as well, feel free to share your comments, and we will do our best to answer them all. But today, I'm very fortunate to have a special guest, an attorney in a particular, who's I should say experienced in and an expert in a particular niche that I've come across in my investing opportunity that I want to share with you guys today. And let's see, I know I told him he had a few more minutes, so maybe I'll stall for a little bit.
Oh, I'm here. I'm here.
Okay.
Just your video turned me off for a second while you introduced me.
Oh, I wonder why we did that.
I don't know.
There you are. Oh, you're on, you're off. Technical issues, it's let's see, why are we off? Hi, non-video. No, that's not you. Okay, well, there we go.
Well, I'm still here and I can still talk, but I see that I'm
Yeah.
just a black screen on your setup there. I don't know what that's about.
Yeah, I don't know what happened there. Let me just check something real fast here. Hold on just one second, guys, while we try to make a technical change. We had a nice, let's see, okay, I just sent you a little message there. Maybe that will kickstart it again. We don't want to have our featured guest, if possible. We don't want him blacked out. And I don't think your camera's off. Actually, it shows
log out
off.
and log back in.
Yeah, Matthew, it shows your camera's off.
Okay, well, I have unplugged my camera and plugged it back in, but it seemed to be sort of being overridden by something. I don't know if it's on your end or not.
I don't think we have any. I see your audio is good. Huh.
Well,
And recording on your end. Maybe that's it. Okay, well, And I just sent a message asking to start video. Did you getting a message from us?
I did, but let's see. I did get a message and I'm pushing on it and it's not doing anything.
I wonder why. It says recording. I wonder if it sends a message out. I'm glad to send you a copy of the recording. If you may turn off, if it's recording on your end, maybe turn that off. That might be triggering it. So, no. Okay, well, let's go with what we got. We'll play the cards we're dealt here. So I came across Matthew. He's an attorney in Rancho Cucamonga. In particular, talk about a topic of partition actions. And so, Matthew, thank you. Video or no video, thank you so much for joining our call today. I appreciate you joining us.
Well, sure. Thank you for having me.
So just a little quick background. I know you're Rancho Cucamonga. A little background. Where were you raised? How did you become an attorney? And how long have you been in practice? Just some of those high points, maybe?
Well, I've been practicing since 1995. I have lived in the Inland Empire, Southern California area since I was 7 years old, and I became an attorney because I guess that's what my dad did. So I saw how to do it and decided to do that myself.
It's funny. My father was also an attorney, and I decided not to be an attorney. So maybe we can have a drink and talk about that one for a while.
There you go.
So you're in Rancho Cucamonga, Inland Empire area, and how would you describe your focus as far as your legal practice?
Well, these days, probably about half of what I do, if not more, is that I get appointed by courts to usually manage or sell real property or businesses. I get appointed as either a partition referee or a Superior Court receiver, mostly in California civil actions.
Okay. And so partition actions, can you explain what is a partition action, kind of generally speaking?
Sure. This is a feature of California law that I'm going to talk to you about, although I think it applies in most other states, but the practical details are California that I'm going to talk about, which is that anybody who jointly owns any kind of property has the right to sell it, sell out their ownership interest. This could be real property. It could be personal property like a car or an artwork or something like that. And if the other owners are not willing to go along with selling it, then the owner has the right to go to court and do what's called partition the property. And partition the property can be one of two things, either taking the property and physically dividing it if it's capable of being divided. So for example, if you owned 100 acres of vacant land and you had two owners, they could physically divide it so each one of you gets 50 acres. Um, when you're dealing with things that can't be divided, such as buildings and things like that, then what they do is they sell the property and divide the money based on the ownership interest.
So, and this comes up now. My focus is in probate, and this comes up where most commonly two parties who are not husband and wife and or don't own property as joint tenants own a property and one dies. So you end up with a person and then an estate for half. Is that a significant portion of the partition business that you see?
About half of the properties that I see are people who have jointly inherited the property. So these will be, siblings who jointly inherit it. Sometimes it's been the family for generations and maybe it's shared by 5, 10, 15, 20 people in very small fractional shares. That's about half of them. Approximately the other half is people who are in a romantic relationship but not married. And when their romantic relationship goes south, they can't go to the divorce court to divide it up because they never got married. And if they bought property together, they have to end up going through the civil side of the court system and go through this partition action. And every once in a while, I see another factual situation, investor or something like that, but that's pretty rare. Usually, the things I see involve people who have some sort of emotional or relationship connection to each other.
And and one wants to sell and one doesn't. That's what forces the partition
Yep,
action.
that's exactly it. Most common scenario that I see is a parent dies and the property is inherited jointly by two or more of the children, and they have real different ideas of what they want to do with it. Maybe one of them wants to live in it rent free. Maybe some of them, the other ones, want to rent it out or sell it because that's their inheritance. And you can't do all those things at the same time. So that's what forces these partition cases.
Right. So I see them in probate court regularly where, and the clue in the MLS also is when somebody's selling 50% or 33% of a property, you go, well, what is that? Well, that's the interest of the property, not selling the whole thing. But there's one of two or one of three parties and they want to sell their share and the other part goes for sale as well, right?
That,
Do you
that
see?
Yeah, I mean, the things that I do are not part of the probate court. So they're outside of the probate court system. And usually the way that you would be able to tell if there is something that's a partition sale is that somewhere in the MLS listing, usually in the private comments section, there will be some notations about that because it has to go through a court confirmation proceeding. And so the buyers ultimately end up having to know that it's not a standard sale and it's going to be a little bit different than normal.
So unless there's an agreement between the parties, then I think you're saying they all, if they're litigation, that by definition that means the court has to prove the sale. So is the process similar to probate, and there's a contract, and that contract is ratified in court, and then is there a chance to
Similar.
overbid
Yeah.
it? Or?
Yeah. Similar. I mean, it operates on a completely different statutory scheme than the probate. So any of the rules or procedural rules that you're used to in probate are not going to apply in this one. For those of you who are familiar with the California Association of Realtors form contracts, you don't use the probate contracts. You just use a standard civil contract or standard residential or commercial process. But basically what ends up happening in my properties is that the judge who's overseeing the partition sale will either order that it be sold by an auction, which is fairly rare, or that it be sold by a private sale. And if it's sold by a private sale, it looks just like any other private sale. There's a real estate agent who's hired, it's advertised, it's listed in the MLS, goes through a standard escrow, you submit regular contracts, things like that. But at some point in the process, before the sale is finalized, the partition referee, which would be me, has to go back to court and basically get the judge's approval of this sale. And there is a potential for overbidding at that time, but it's fairly rare that people do that.
It's rare. Now, is defined in the sense that it has to be a certain amount, or
Yeah.
do you as a probate referee have the discretion to determine what's best for the transaction?
So the reason that it's rare is because it does have minimum statutory bids for the overbid process. And the minimum statutory bid is 10% of the first $10,000 of the sale and 5% of every dollar after that. So
Same as the probate court. So
yeah.
still, but 5% is significant. And then do they also at that point need to be coming in waiving conditions and contingencies and coming in with a 10% or more deposit, or what does it
So
look
there's
like?
no specific requirement on the deposit. In order for the bid to be considered, virtually every judge that I'm aware of would require that at the overbid process, you have all your conditions, contingencies waived. But very few people do the overbid, by the way. And the reason for that is because when this property is on the market, it's offered on the market to everyone in the world. And if you can have the highest bid by $1 in that process, why would you want to try to get a 5% over in an overbid through the court when you have to do all the, waive all your contingencies and be willing to perform basically right then and there?
Well, I think, not to argue, but just to maybe answer the question, on the rare case somebody would, it's like probate, 90% are done properly, but 10%, the agent's trying to hide the deal somehow, sell to their friend on the cheap. And I'm looking for that one deal to come in with my investor and buy it and give the estate a better price. And so I wonder if that happens from time to time. And that's what we'd want to look for, I guess, if that's a possibility. Do you see that happen from time to time? Do you see?
I've never seen that factual scenario. I've never seen it where I go into court asking the judge to approve something that I might have doubts about whether it's the highest bid or the best bid or whether it's been offered on the market. So it's usually something that's advertised. It's out there. We're going to get multiple bids. We're probably going to go through some rounds of bidding between people who are submitting bids, and then we go in with what's the highest bid. The other thing to keep in mind is that this partition sale, when you're doing the sale confirmation, there's no time when the entire world is notified of the fact that there's going to be a sale confirmation hearing. So it's real easy to find out that the property is for sale. There isn't any effective way to know that the hearing is going to happen, because the notification for the hearing by statute is required to be given to the potential buyer and the current owners, and not to anybody else. So if I didn't know, for example, that Bill Gross wanted to put a bid in on this one, I wouldn't have any reason to give Bill Gross notification that there's going to be a hearing, and Bill Gross wouldn't know there's a hearing.
Got it.
So the time to bid on these things is mostly when it's for sale, offered to the rest of the world.
Like any other property. Oh, interesting. Now, you are in Rancho Cucamonga, which I think is San Bernardino County. Is your practice primarily, exclusively, or split amongst different counties?
I work in all over the state of California. I would say the majority of my cases are in Southern California, but I'm all over the Southern California area, and I have some cases in Northern California as well.
Okay. And now, if I ask a question that's confidential or uncomfortable, feel free. I'm kind of that way. But when the time comes to list the property, if you're the referee and you're managing that process, how do you decide who the agent should be in a certain area? Do you have a Rolodex already? Do you put it out for bid somehow? Or what do you do to determine who should represent the case as far as getting the property sold?
So I decide in every case who's going to be the real estate agent. Sometimes the case comes with a real estate agent already associated with it. Sometimes the existing owners are requesting that I use a particular agent. I like to use agents that I have used before who understand the partition sale process, because it is a somewhat unique process. And I find it's very difficult to find people with expertise in it. So if I have someone who's done 5 or 10 or 15 of these, there's a good chance I'm going to want to try to use those people in the future. But we also look for people who have geographic expertise or subject area expertise if it's an unusual property, or if it's in a property that has its own unique market.
Okay. Now, mechanically speaking, as an agent, if I'm technically I'm representing both parties. I'm representing
I think you're representing the partition referee, who's the person who hires you. So the job of the partition referee is to manage the sale. And so my job would be to select a real estate agent, hire the real estate agent, sign a listing agreement, and then be the party on the seller side who does all the negotiations, signing of contracts, things like that. One of the big reasons that people do use partition referees is because if you have an owner who is either missing or uncooperative, it is a way in which you can transfer title and sign documents and sign contracts where you don't need to have that owner's cooperation. So the referee is empowered by the court basically to sign on behalf of the owners.
Wow. How hard is it to get to where you get a referee assigned by the court? You file a petition for partition, but I imagine if it's contested, you're talking about you have to have, hearing and a judgment by the judge, ruling by the judge as far as to order it, correct? It's not just something you file for and get appointed, but both parties are, if they're fighting it, there must be some sort of adjudication process, correct?
Yeah, so it's a two-step process. Step one is that whoever wants to be selling the property has to file a lawsuit and list as the parties in the lawsuit anybody who has an ownership interest in the property. And that at some point, a judge will decide whether partition is appropriate, and if it is appropriate, what type of partition, whether it be by physically dividing it or partition by sale, and then what kind of sale is appropriate. At that point, then the judge would enter an order that approves the sale of the property and tells the referee, basically empowers the referee to go out and actually sell the property. And then once the referee is done selling the property, then the referee reports back to court and tells the judge how much money was created by the sale. And that's when the second part of the lawsuit happens, where the parties who had formerly been co-owners of the property have a right to make claims to the proceeds. And so the default is that they divide up the money based on their ownership interest. So if you're 50-50, each party gets 50%. But as part of that process, they can also look back over their entire period of co-ownership. And if one of them paid money for common expenses that are disproportionate to their ownership percentage, then they can get that reimbursed from the sales proceeds before the proceeds are divided. So the most common things I see with people doing this accounting at the end would be one party who put in more money for repairs, insurance, property taxes, or perhaps they'd operate as a rental property, and one of the people kept more than their fair share of the rents, for example.
Sure.
How
do the legal fees get? One party files a lawsuit to force the sale, and the other one, maybe doesn't have an attorney. Is the one that files the lawsuit, is that the expense out of their pocket? Do those fees eventually get split equally based on the percentage of the ownership? How does that get worked out?
So the judge has the authority as part of the partition case to authorize and approve the award from the sales proceeds of attorney's fees for the prevailing party in the case. There actually is some case law in California that allows both attorneys, potentially on both sides, potentially to be paid from the sales proceeds before the property is sold, or before the proceeds are divided up amongst everybody.
Now, we've talked about your role as a probate, as a partition referee. Do you also handle, in different cases, of course, handle the legal work of filing partition actions and getting them to somebody else as a referee?
So I don't. I could, but I've chosen not to. I'm legally licensed to do that sort of work, but I find that it's very hard to be both an advocate in the system and also the referee, because as the referee, I'm appointed by the court system and I'm required to be neutral as between the parties.
Right.
And so I'm not an advocate for one side or the other. And so it's really difficult for me to be an advocate in some cases and then turn around and be the neutral guy in other places.
I see that in probate court, that they'll pick one of their colleagues as the temporary or acting, temporary administrator. I always think, how could you do that? One day you're fighting against each other, killing each other on a case. The next thing you know, you're referring to more business to the guy who seemed to me is the last thing you want to do. Somehow some attorneys enjoy that tiptoe action, but I don't understand how they would do it. It sounds like you just stay clear of that.
From my point of view, I try to stay clear of that.
On a standard residential property, whatever average is $800,000 or so, what kind of legal fees and expenses all told in is somebody? Let's say if you're 50% owner and the other party forces you to litigate, you got your legal expenses to get to you as a probate referee. I'm sure your expenses also come out of the proceeds and the court expenses. You have a ballpark on a full litigation, not extraordinary one, but like a standard kind of litigation, or typical the fat part of the bell curve, what it might cost to get that far?
So there's two layers of fees that you'd be concerned about. One would be the fees that the parties, the owners, attorneys charge to them individually. Mm-hmm. And then the other would be the fees that are paid to the partition referee. So I can't really speak too much to the fees that the attorneys charge to their own individual clients, because as I say, I don't really handle those kind of cases. They'd be standard lawyer litigation fees. They're probably obscenely expensive. That's just how life is. For the partition referee work, I am paid by the hour. I do not charge a percentage like a real estate agent or anything like that. I'm paid by the hour for the work that I do. And the work that I do in a cases ranges from a low of maybe 20 or 30 hours in a case to, if it's a very contested case where the people are not being cooperative and requires a lot of work, could be 100 or 200 hours of my time.
And is there a standard hourly rate the courts agree on, or is it something that's negotiated? Or how's that?
Typically, when I'm appointed, the judge will set the fees. So the order that appoints me will have an hourly rate that's approved in advance.
Are you able to share what that is?
It's usually about $300 an hour.
So you're talking, you said between 20 and a high end of 100 hours at 300 an hour could be $30,000. So $6,000 to $30,000 for your portion. Doesn't even count the attorney. If you're not the prevailing party, you might have two sides of attorneys to pay for. So
it's true. Usually the referee's fees, what I notice is that they tend to be smaller than the real estate agent's fees, the commissions.
Interesting.
Not all the time, because they're not, they're on completely different scales, but I just, at the end of the cases, sometimes I add them up, and the agent commissions at, 5 or 6% tend to be higher.
One of the things that I've experienced, and you and I talked a little bit before we started today, was that a percentage of these cases settle before they get down to the end. Sometimes, unfortunately, it takes hiring an attorney and filling out the forms and filing to the other party and serving the other party before that will happen. You say you see that happen from time to time. Do you have any idea of what percentage that happens versus a full litigation?
My guess is it probably happens a fairly high percentage of the time, because I talk to a lot of attorneys who call me up looking for my services as a referee, and they'll say something like, I've handled cases like this for years, and most times people settle, but in this case they didn't. So that's a very unscientific sampling. I only see the ones where there's the bitter enders who aren't settling, and it's going through the court system and the hard way rather than the easy way.
It seems to me it's almost like it's their hobby at that point, right? You could spend the money going to Hawaii. We can spend the money, I guess, buying an RV and touring America. We can spend the money on attorney's fees and a probate referee. Not that you're not fun and exciting and interesting, but
I'm not.
But it's like the people who just really want to spend the money on the attorney's fees, and they just don't really care what the reality is on that. So
I think most of the time it's either guided by emotions, or people have something that they're really truly fighting about that they think they're going to win on. Maybe they think that they're entitled to a lot of money on reimbursements at costs at the end or something like that. I mean, there's a lot of moving pieces in one of these cases. One of them is, do you have an ownership interest in the property? But that's often not the biggest one. Oftentimes the biggest interest is amongst the owners, how to divvy up the money at the end.
I think you're right about the motions, because I see in probate court, and the ones that I've seen, the partitions where they went to court confirmation in probate court was, one of the owners was related to the decedent, ex-wife or something, and they're upset at the other party because they did something wrong to them, and they can't allow them to have the property on the cheap or live. You're right. It seems to be, to go that far, there has to be some emotional component to the process.
Yeah. One of the aspects of the California real estate system, or any state primarily, is that if you're going to sell the property and it's jointly owned, at some point you need everybody's signature. And a single person who owns 1% of the property can hold up a sale by not signing it. And so that's why you end up with these cases, sometimes these partition cases, because you might have 5 or 10 or 15 people who own the property jointly, and one of them doesn't get along with the rest of them and doesn't want to sign anything.
Right. I think that's a lot more common on the East Coast, where settlement was earlier than California. I know that there's a major social issue in the South, and particularly post Civil War, where families were given large tracts of land, and then it was back in 1870, and so it's old enough that enough generations, and back then they had more kids per, and so I've seen properties come up. The term they use there is heirs property, where people might have 40 or 50 decedents identified in a property, and there's a couple holdouts out of the 40 or 50, and I imagine just getting all of the notices signed is quite an expensive endeavor. So that's, I guess, inevitable to happen here, not as common, but in other states definitely happens more regularly.
Yeah, I've never seen them as high as 40 or 50 in my cases, but it's fairly often I get between 5 and maybe 10 or 15 people owning the property.
That's tough. It's really, that's why not in this call. I do a call on probate, called Probate Weekly, and I'm on there every week trying to tell people, get a living trust. If you own property, just solve problems for your decedents. I mean, for your heirs, because at least you have a better chance of avoiding litigation if you at least take the trouble to put everything together on paper ahead of time, I think. Well, look, I appreciate the chance to ask the questions. I find this topic fascinating. I can go on for hours, but the goal of this program is to be a little more participative. So we have an expert on this topic of partition actions, selling real estate when there's multiple parties, one wants to sell and one doesn't want to sell. If you guys have any questions, I don't see any in the chat box. Maybe you're just too engrossed in my interview process and my interview skills. Anybody have a question, you can either put in the chat box or raise your hand, or if you just want to mute yourself and jump in, this would be a good time to do that. Dave Weineman, go ahead.
Just a quick, out of coincidence, have you ever worked with a fellow by the name of David Shea? Attorney by the name of David Shea?
I have not.
Okay. Unfortunately, I had to work with him too much with my parents' estate and my siblings that were very unhappy with the outcome. And it just went on for much longer than it should have. But he was the court-appointed receiver.
Okay.
In that situation, and there wasn't anything like you described here with the assets, but it was a cumbersome process. And he was, in hindsight, I'm looking back, and he was really sharp and did his very best to be as fair as possible. So there are some good ones out there like you, Matthew.
Oh, thank you.
Sure.
Justin, I see your hand up.
Yeah, Matt, what do you think about the receivership cases? Do you think the court sometimes oversteps their boundaries and pursues land grabs?
Well, so receivership cases are different than partition cases, and I act as a receiver also, so I'm happy to talk about that. It's a very, very different process than what we just spent the last 20 minutes talking about. But my experience with receiverships, for the most part, is actually the opposite, which is that most of the judges are very reluctant to appoint a receiver to take over something like a business or a property, because they're very leery of starting something that's hard to get stopped once you start it. It's very hard to stop a receivership once you get it going, and so a lot of them, I think you have to have really good grounds for showing why a receiver might be appointed. My experience with doing receivership work in the real property arena, at least, and I'll focus on real property because of the nature of your podcast, is primarily what's called rents and profits receiverships, where I might be appointed to operate some kind of a business that generates rent, like an apartment complex or something, for a short period of time while the owners or some creditors or somebody is fighting about the property, and they don't want to lose the rental income stream. So they'll appoint a receiver for a period of time to operate it and do that. So that's my experience with real estate receiverships. So Justin, yeah, to answer your question, I haven't experienced too much of what I think you're talking about.
Okay, thanks.
Thank you. Any other questions, comments? And if you're watching it live on the live stream on YouTube or Facebook as well, you put your comments in and they'll pop up here. I could answer them. Or if you watch it afterwards, put comments in, I'll answer them afterwards, or I'll do my best to refer you. But seeing any questions, we have an expert on the topic here. I find fascinating. I think it's both in terms of the specifics and as well as just the concepts and principles. Winston?
I've got a question, Mel. This is interesting to me as well. So I'm going to ask a naive question, but it's something that maybe all of us can benefit from. Matthew, if we as real estate brokers wanted to learn more about this process, now with probate court, we can go to the court, we can watch, we can observe, we can meet the attorneys. If we want to learn more about this process and eventually get to the point where a guy like you would hire one of us, what advice would you give?
Well, if we're talking about partitions in California, there is a discrete body of law that deals with the rules for partitions. It's Code of Civil Procedure 872 and 873 and a whole bunch of things around there. It's about 20 pages of it. It describes the process in very fine detail. I would start off by reading that. There's a fair amount of stuff that's online. If you just type in the word partition referee, there's a fair number of people who have posted informational articles and things like that. I have a couple on my website, but I know that many other people do as well, to kind of give you some of the details of that. I think it probably makes sense if you can find some sort of an organization that where referees or receivers congregate on a professional basis. That makes sense. There's an organization called the California Receivers Forum, and that is something that you can join, and they have educational meetings periodically. I've been a member of that since 1995. It's a real good resource, and a lot of people who are involved in this area of law get involved with that. And I've seen a lot of real estate agents as well who are involved with that as well.
On that topic, are all partition referees attorneys?
No, you don't need to be. There's no legal requirement at all. In fact, the only requirements there are for being a partition referee is I'm going to call some negative requirements. There's things that will eliminate you from being a referee. And it's basically that you have some connection to the parties or to the judge administering the case. So as long as you're free from those sort of things, there's no licensing requirement, there's no education requirement, there's no specific requirement on passing a proficiency test or anything like that. The hardest part that you would find if you're trying to become a referee is that you have to be appointed by a judge, and it's discretionary. And the judge may look at the qualification of someone who's never done it before and say, I'm not going to appoint someone who has no experience at all.
Sure.
So the way that I personally got involved in this business was complete random blind chance. Out of law school, I got a job working for a firm where one of the people acted full-time as a receiver and court referee. And I started doing some work for them. And after that person retired, I continued doing the work.
And judges know who you are, and
you get a resume, and you can come in, and I got a resume that's 15 pages long, and it's got dozens and dozens and dozens of these things before. But that's, it's like a snowball. It grows and grows and grows. And, the first 2 or 3 cases you've done, it's not real impressive looking. And after you've done 50 of them, then all of a sudden people think you're an expert.
I would say at first glance, your resume is extremely impressive. I saw the UCLA Law School though, and I at that point got a little bored with the whole thing. So
sorry about that.
I have to throw that in. Okay. And then, so.
Right on.
Thank you, Louis.
Now I just start, I'm going to do this during football season one day, and the whole thing is going to degrade into a contest. So to get the business, but in terms of meeting with other partition referees, then it makes sense that most are going to be attorneys, in that you're in a litigious environment. Probably you get I'd imagine if you make a mistake, they're threatening to sue you or order things to the judge, and that the judge won't pick you next time. So I imagine that's typically aren't partition referees typically going to be attorneys, or are you just particularly well qualified for this?
Virtually every partition referee I know is an attorney.
Yeah.
When you go into the field of receivers, there are more people in receivership business who have a background in property management. So I've seen a fair number of property manager people doing receivership work. A lot of the reason why they will pick an attorney to be the receiver or a partition referee is because you ultimately end up having to need some legal work done for you in your communications with the courts and things like that. And so if you're a referee who is not an attorney and doesn't really know what you're doing in the court system, you're going to end up having to hire an attorney. So that's an additional level of cost.
Right.
So a lot of times they look for an attorney because then, for example, I do my own legal work and I don't have to hire another law firm to do it.
Now, does that make you the classic case of hiring yourself as an attorney?
It does. Well, I don't act as an attorney at that. I just kind of, perform my own stunts with the court system.
Got it. Okay, good. Whew, we won't have any problems there. Okay, good. So other questions, comments? This is interesting. I find this fascinating. I don't know, is it me? But Winston, you have another question?
Yeah, Bill, I'm still kind of stuck on how we could, like, again, going into the probate court, we know where to go. We know what courtrooms.
Right.
How do we find out about a petition hearing taking place so we can go observe? That's what I would like to know.
Well, I think what Matthew's saying is that it's not as available except in the MLS. Now I'm in Claw. I know you're in Orange County, so different MLSs. But you might want to just do an MLS search on keywords for court confirmation if it's not a probate, or keywords for partition, and see some pop up. That's what I started doing when I started in probate. Was I would just search the MLS for cases, and I started reading what those agents did in their notes, and I started I learned a lot just by reading the MLS of different competitors, and then seeing who the owners were and seeing who the sellers were, things like that. So that would be any other suggestion, Matthew, that you'd make as far as an agent like Winston looking to break into finding these cases? It sounds like they're not really available other than through the MLS for the most part.
I'm not aware that the court system has any sort of an index that shows that. I mean, once you know the name of a particular case or a case number of a particular case, all of the documents that are filed are publicly available documents. Every court system around has the documents available online these days. So if you happen to know the name or case number of a case, you can get a lot of information about it. But his question was more, how do you find out the case exists in the first place? And I think Bill's suggestion would be the best one. I know that when I'm doing partition sales, I ask my real estate agents to have a fairly extensive set of comments in the private notes section of the MLS that will describe the process and will describe, disclose from day one that it's a partition sale and what some of the requirements for. So if you can do a keyword search on the word partition, you'll probably pop up a lot of things there.
Or percent interest. I think 50% interest or 30, not 30, but 33% interest or percent interest. I think if you search those key terms, I think you'll find some of those cases. What's interesting, I've been looking to try to find a way to find the particular motion. And unlike probate, where you have a standard form, petition and file probate, or you have a Hegstead petition, you have an 850 petition, it seems like the wording of the motion to file is inconsistent because it's a different case that all of a sudden somebody's litigating and then they force it to probate referee, correct? Is there a particular form that gets filed to appoint a probate, a petition referee? Is there
Well, the lawsuit would be filed, and it's somewhere in the caption of the lawsuit, it would say that it is for partition of real property. Many of the counties around have they will provide a face sheet of every single lawsuit that has been filed that people can look through. And so if you go down to a particular clerk's office at the local county court and you ask if they have the basket with the face sheets, you'll find that many of them do have that. For example, I just out of curiosity one time was at the Superior Court in San Bernardino, which handles most of the ones for the county of San Bernardino, and they have a big basket in the clerk's office. And I spent about a half an hour flipping through every single one of these things and to look and see how many partition cases there were that had been filed. And you can tell, if you know what you're looking for, you can tell in about a half a second if that's a partition case, because it'll say it right on the face. And then that would be a way to get into the system of figuring out if there's a particular case pending that's that type of case.
Interesting. In probate also, there's different companies that as a service will pull all the probate filings and sell them as a data source pretty inexpensively. I've looked around, I've not seen anything equivalent for partition actions. So any of us who are doing this, and I'm sure it varies a little bit by county, as you're saying. So Winston, if you find the secret sauce in Orange County, report back to us. Let's hear how successful you are. And anybody listening in other counties as well. LA, we don't have a basket. You really can't get in and look at it the same way. I'm sure online there's some clues. I keep looking for it myself. So anybody has any suggestions, I'm definitely all ears.
I believe that every one of the county courts has some equivalent to that. It may not be a physical basket, but there are businesses that collect this data and sell it. And they have to get it somehow. And I believe that the way they get it is some form of a data dump from the court system. And I don't know what that method is, other than I've seen in some courts they do have this basket.
Yeah. The other thing that what prompted me in this was really looking for people who didn't want to follow the action to get to you. They were just willing to sell their 50% interest. And generally, they sell that, they're going to get about 60 to 70 cents on the dollar of the retail price of the property. Because now you can't finance it. You can't finance half. I mean, you can, but not at a regular mortgage rate. And you can't sell it unless you force a partition action, and I want to go through all that process. So I happen to have an investor who does that, and he'd look for more. If I could find more, we would do more. So
Bill, I've actually seen some people whose business model appears to be that they purchase fractional interest in property at a discount, I assume, and then force the partition.
Yeah, that's what we've done a couple of times. And so my investors ask me for more of these, and I can look in the MLS and find the fractional interest, but there's not enough to, I mean, it's like anything else in real estate. The more deals you find, the more money you make. So there's only so many at a time. But definitely that is a business model. I know in probate court, we bid on all of those. because they do sell for, if it's a bidding process, it's not going to, it move up a market, but you're only, if it's a fractional interest, you're not going to get the share of the retail value. It just doesn't work that way. And so I've had investors buy 2 of those, and he'd like to buy another 10. One of the morals of the story for everybody on the call, if you're an investor or you're a wholesaler, you're out birdbagging properties, if you find these things, it sounds like a problem. Don't give up on it. This is where we get paid is to unwind these problems, and whether it be to hire an attorney or to get the advice of an attorney or bring it to me if I can help game plan what to do with it. But this is where personally I think I did 2 of those last year where my investor bought the fractional interest. One we forced to sell, and they actually capitulated once we filed the lawsuit. They didn't force the whole trial action, which is great. So, okay, any other questions, comments? We have a guy on the line. Our guest today is $300 an hour. I'm not going to pay all of that bill. I'm going to pass the hat to the rest of you guys on the call today. Anybody? Let's take advantage, though. We have a real expert here. Any other questions, comments for Matthew Taylor?
Yes, this is Gary. I may have missed it because I had to step away from my desk, so I apologize if you've already answered this. But is there a way to, I'm thinking you acquire a fractional interest so and you can, force the sale. I mean, was that the business model you were talking about, Bill, a short time ago?
Yeah, we bought one in probate and one retail where 2 parties, one wants to sell, one doesn't. The one that doesn't sell, real property is worth $1 million. His half interest is not worth $500,000. As a fractional interest, it was worth about $300 or $350. We bought it for $315. And now, a year later, of course, everything's gone up 20%. A year later, it's worth about $1.2 million. And my clients, filed a petition action. And as much as the other guy protested he was going to fight it, once he got served, he capitulated, and now we're put out the property on the market. So. But yeah, there's a business model to look for these fractional interests and then try to unwind them.
Well, and Gary, in California, you have an almost automatic right to compel a partition if you own a percentage of the property. So as long as you can prove that you are a co-owner, even 1% of the property,
wow,
you have the right to force the partition of the property.
Wow, that's cool. I know.
So I'm just trying to think of how you would monetize that. And I'm probably not going to do this, but just it's a fun thing to think about whenever somebody presents you with something. I mean, if I somehow found somebody who had a 1% interest in a property that people wanted to hold, and I could force the sale of that, and I could get access to that 1% fairly cheaply, because what's 1% worth? Right. I mean, a nice one thing to do is to say, listen, I'm going to sell this property. I mean, it seems kind of underhanded, though, but I'm going to sell this property unless you buy out my interest. I mean, that seems a little underhanded, but I'm trying to come up with a revenue model that would work here. Any thoughts?
Well, practically, it's also just not from a legal, but from a practical point of view, it can be difficult to buy out 1%, depending on how big it is, right? It's because you're talking about cash. Typically, you can't finance the fractional interest. It's not going to be a residential mortgage rate. They can refinance in general the whole property and pay you out that way. But if when it's more than that, when it's 30 or 50%, it becomes impractical to pay off a minority owner,
right?
Because the cash requirement's too big.
Right.
Bill, can I jump in?
Yeah.
So I've handled a lot of partition actions from both sides. And one of the things as real estate investors, which is what most of us are involved in here, you have to be, when you're buying a property with someone who you're not related with, sometimes even someone who you are related with, it's important to have a management agreement. That's the first thing that I advise clients when they're coming to me with these kinds of deals. You have to have a management agreement so that if that covers 100% of the ownership, so that if it comes down to someone wants to get out, it's already been determined how it's going to happen, so you can avoid a partition action. Because what I have found, as with a lot of litigation, no one wins a partition action except for the lawyers, so it's okay. So if you have a management agreement in place and you know who gets to make the decisions, and if someone doesn't like it, how much they get if they want to get out, then that solves this whole area law from the investor standpoint.
Yeah, and in fact, to your point, to get a mortgage loan from a Fannie Mae or a standard lender, you would need to have a management agreement. If you're buying the property as tenants in common, they would actually require that in order to finance it, because the lender doesn't want to get involved in any litigation for sure. Winston, I see your hand up. Did we answer your question? Do you have another one?
Yeah, I've got a new one here, Bill. I'm just curious, from the point in time where a partition action is filed and a partition referee is established, with the court system today with COVID, what kind of timing are we looking at? I know it's probably a high and low, but what would be a middle of the road period of time to get these things settled?
Well, so I can only speak to how long it takes me to sell a piece of property after I'm appointed. So I have no connection to the case from the time it is filed until the time I'm appointed. And so once I'm appointed, generally speaking, it's anywhere from 3 to maybe 10 or 11 months or something between the time I'm appointed and the time we can actually close escrow on the sale. It depends a lot on how cooperative the owners are with my efforts. It depends on how often we have to go in and touch the court system. For a period of time, COVID was really shutting things down in the court system, but most of the courts have reopened enough that that it's not presenting too much of a delay in what I'm doing. We kind of do things differently. You know, my hearings might be on a Zoom type call rather than in person in court, but they're doing a pretty good job of processing the hearings and moving them through.
It seems like things have really moved up faster in most stuff. I know somebody in probate court in San Bernardino County says they go there in person, they get the order presented and signed by the judge that day. In LA, we don't get that for weeks. But LA is moving more and more to video, and I know the judge issued last week, just a couple of days ago, the order that they're going to offer the video for free starting in September to try and encourage people to stay out of the court system. So they're definitely figuring this out and moving things along faster.
Sure. Many of the county courts are doing some form of either telephone appearances or Zoom type things. But going back to Winston's question, though, one of the biggest delays that we were having for a while is that as part of the sale, we were required to record at the county recorder's office at the time that we transfer the property, a certified copy of the court order approving the sale. And some of the court systems just simply shut down and weren't processing those.
Correct.
So I had things that were delayed for 3 to 6 months because we couldn't get that. Basically a copy that before COVID would have been a thing you get at the counter. You walk up and 10 minutes later you have it.
Right.
That seems to have gone away. Most of the counties seem to have opened up enough, so we're not having that as a problem anymore.
Meanwhile, 3 to 6 months later, the property has gone up, 7% in value. So
yeah, there you go.
Whatever it is. So
maybe not always. It's never easy or good. And it might, the property might have been vacant 6 months later, might have squatters in it.
So a hand in the book, a bird in the hand is much better.
That's always my advice to my clients. Yeah. Ellis, I see your hand up. Do you have a question for us?
I do. If you have a partial interest in a property and you're untitled, you would also have liability for anything that would happen to that property. Is that correct?
Correct.
So I'm in a kind of a similar situation. I'm hesitant to go untitled. I have an option for the percentage interest, but I'm very hesitant to exercise that until we complete the partition, because it's basically uninsurable. If you have I'm uninsurable. I talked to my insurance person and said, look, I'm thinking about getting a percentage interest of this house. Is there anybody that would insure it? Have you found that to be true as well?
So most times I see the owners just simply getting regular insurance from whoever. There's a private home, be homeowners insurance. So I haven't seen that that's a real problem for the owners to get insurance if they're co-owners. Also, I'm not positive how you would exercise an option to purchase the property after partition sale, because after the partition sale, the person who gave you the option would no longer be the owner of the property. So you may want to be careful about that.
Interesting.
It's a recorded option, so it's untitled, so it has to be rectified through title. But if I'm an owner, if I take title to it and I'm not occupying and I have no control because it's the person that is occupying the property is hostile toward the partition, obviously.
Mhm.
That's why I'm kind of hesitant to go untitled too soon.
Well, a hostile occupant is a very common feature of partition cases.
Yes. Yeah. As a real estate agent who's been on those, that's, I think, par for the course. The good news is I don't have to go there to do photos or inspections or showings. The bad news is I can't to show it to a prospective buyer, so we're not going to get top dollar. It's always hostile is the legal term for it, but I think it's a little bit more than that in reality in some cases. In fact, legally, I think there was a case in Huntington Beach, I think a couple of weeks ago, where there was that's what that was about. I believe a real estate agent and three of the people shot at a property showing where the agent was showing it, I think, to an inspector or two, and there was a hostile occupant in a probate case, I think, if I remember right. So definitely be careful. Okay, well, coming up on the closing hour here. Any last questions? I don't see any hands up. I think we covered everything in the chat box. And if you're watching live or afterwards, you put questions in that I can answer, I'll answer them. Matthew is very generous to be on today and not charge an attorney's fees for doing that. It's really part of his service to our community. So I really appreciate that. Any last questions from anybody before we wrap up?
Well, Bill, can I ask or talk about something that I think people ought to be aware of?
Yeah, please.
Several people have asked some variation of the question of how, as an investor, can I get into this? But I'll tell you, where I see this as a bigger issue that it might touch people in the real estate community is if you are a real estate agent and you are trying to list a property for sale, and sometime during that process you realize that there's an owner on title who is not cooperative. That's the point at which you would realize that it is in need potentially of the partition process.
Right.
So that's a fairly common scenario that I see, where the owner kind of naively believes, well, they can sell the property even without the other person, and it's the real estate agent who figures out that, wait a second, pulled a title report or something and realized there's more than one owner on the property.
The guy was married. He has an ex-wife in the background, and he tried to get away with it. Or there's a couple other kids, or the son doesn't tell you he's got two brothers and one's hostile. Yeah, no, that's standard. Why we get a prelim right away when we list the property and try to find out who's in charge here. So thank you. Thanks for that reminder. So good reminder, everybody. Make sure you get a preliminary title report right away when you list property and review it. Make sure you have everybody that you need. Otherwise, you might see Matthew Taylor in court and not want to be there that long in the process. Not that we don't like you, Matthew. I certainly appreciate the time with you, but I'd rather see you once in a while on a Zoom call than to have to deal with it in a court situation.
Sure.
We won't recognize you, Matthew, but we know your name at least.
Thank you. I've spent the last 45 minutes trying to get that camera to work. Bill and I were sitting there on the camera working, no problem whatsoever. And literally the second they said, okay, we're going to stop recording, the camera stopped working. And I got to think it's some software issue with the recording.
I think it's a Zoom. I know I'm using different softwares. I know it's on the Zoom side. I'm pretty sure that's where it comes down to. Yeah. Zoom is just, it exploded in usage during COVID. And I just, having used it multiple times a day, every day for the last year and a half, it seems like there's regularly problems on that end. That said, you did the most to make it interesting for us. On behalf of everybody on the call here, I just want to thank Matthew Taylor, attorney from Rancho Cucamonga. Thank you so much for your time today of answering questions. And I think, again, a lot of this stuff is elementary for you, so I appreciate you helping explain things to people and help them hopefully avoid being in a partition situation. Of course, if they know anybody who needs a partition referee, you'd be a great qualified candidate for them. But thank you so much for your time today. I really appreciate it.
Sure. Thank you very much. Thank you for having me. And I really appreciate being here and enjoyed the questions.
And everybody else, thanks for being on today. This is Real Estate Investing Zoom.com. We do it every Tuesday, 3 o'clock. We also stream it live on YouTube, Facebook, and LinkedIn. If you're there live and have questions, I'll respond to all of them. If they're for the guest, I'll do my best to follow up. Of course, he's a busy guy and expensive, so just be careful with those questions there. But I appreciate your participation and support. Feel free, if you're on it now, to like it, subscribe to it, and that way you'll get notified whenever we go live on our event. So thank you so much. I'm Bill Gross, the LAProbateExpert.com. Make today a great week. Thank you so much.